Parliamentarians in the National Assembly of St. Kitts and Nevis approved the passage into law the Whistleblowers Protection Bill 2023 and the Unauthorized Disclosure of Official Information Bill 2023. The bills were introduced by Attorney General Garth Wilkin and were debated for several hours. According to the Attorney General, the Whistleblowers Protection legislation would encourage persons to disclose acts of corruption in the public interest.
The Whistleblower Protection Bill seeks to establish a robust legal framework that encourages individuals to disclose information about acts of corruption in the public interest. Recognizing the invaluable role public servant whistleblowers play in safeguarding the interests of our Federation, the bill aims to extend legal immunity to these individuals in employment-related legal proceedings or sanctions. The provisions of the Whistleblower Protection Bill are designed to cover a wide spectrum of disclosures, ranging from criminal offenses to threats to health and safety, environmental risks, and acts of corruption. It sets out specific entities to which whistleblowers can disclose information, ensuring that the process is guided by the principles of accountability and transparency. Crucially, Madam Speaker, the bill delineates protected disclosures related to national security, allowing for a specialized procedure when matters involving the national security, defense, international relations, or environment of St. Kitts and Nevis are at stake.
The Unauthorized Disclosure of Official Information legislation seeks to protect government from the unauthorized disclosure of certain types of information as explained by the Attorney General.
So, Madam Speaker, at its core, the Unauthorized Disclosure of Official Information Bill 2023 endeavors to bridge a legislative gap by establishing criminal offenses for the unauthorized disclosure of defined damaging and confidential information. We have drawn inspiration from the UK Official Secrets Act 1989, and this bill integrates the above-mentioned privilege matters contained in the Freedom of Information Act. That's why I say it's a sister act. So as we advance with the comprehensive legal reforms and good governance, including the 5 fundamental and interlinking legislative pillars to sustain the good governance institutional infrastructure in St. Kitts and Nevis, we recognize the need for a legal fortification against unauthorized disclosures of confidential, sensitive, or privileged information. Critical sections of the bill, Madam Speaker, namely sections 3 to 11, criminalize unauthorized disclosures of information related to matters of national security, international relations, crime and special investigation powers, other unauthorized disclosures, information resulting from unauthorized disclosures, or entrusted in confidence, and information entrusted in confidence to other states or international organizations. In Section 8, the other unauthorized disclosures involve information within the boundaries set by the Freedom of Information Act. I want to make that clear. This act works as a sister to the Freedom of Information Act. It includes confidential government communications, prejudicial commercial communications, matters related to health and safety, information about sustainable development, and more. This section fortifies the protection of sensitive information, ensuring the government's ability to operate effectively without compromising its duties to the public.
The Freedom of Information legislation, however, allows the public to access non-sensitive government information through approved channels. Glenn Bart reporting for SK Newsline.